It is my pleasure to introduce our speaker, Franklin Freeman. Now, I know that there are a lot of accomplished folks in this audience, but after I read this bio, I think you'll all see that you still have work left to do. Franklin is or has been all of these things. Graduate of the University of North Carolina School of Law, member of the Order of the Golden Fleece, Carolina's oldest and most prestigious honorary society, law clerk for Supreme Court Justice Dan Moore, professor of public administration at the School of Government, senior assistant for government affairs to Governor Mike Easley, justice on the North Carolina Supreme Court, chief of staff to Governor Jim Hutt, secretary of the North Carolina Department of Corrections, director of the Administrative Office of the Courts, assistant district attorney, administrative assistant to North Carolina Supreme Court Justices William Bobbitt and Susie Sharp, consistently named one of the most influential lobbyists in the state of North Carolina, partner at McGuire Woods, and perhaps most importantly, dad, father of Wake County District Attorney Lauren Freeman. I can think of no one more appropriate to come speak to us today about the establishment of district court. Please join me in welcoming Franklin Freeman.
Thank you, Ashley. Good afternoon to all of you. As Henry VIII said to his wives and Elizabeth Taylor to her husbands, I shall not keep you long. Mark Twain said it was a terrible death to be talked to death. Dean, I'm not looking at you purposefully, if any. Distinguished members of the Wake County Judiciary, dear Doris, fellow members of the bar, ladies and gentlemen all. Many years ago in my native Dobson, we had a fellow that was doing a little preaching. Met this preacher, and he died and got up to heaven, was met at the pearly gates by St. Peter. Immediately ahead of him was a cab driver from New York City. St. Peter admitted the cab driver, adorned him with an ermine robe and a golden staff, and passed him through. My Methodist preacher got up there. St. Peter gave him a cotton robe and a wooden staff. The Methodist preacher said, St. Peter says, I don't rightly know what's going on here. Says, for 40 years I've preached the gospel every Sunday. What did this cab driver do? St. Peter said, yes, preacher said, for 40 years you preached the gospel every Sunday, and for 40 years you put people to sleep every Sunday. For 35 years, this cab driver drove a cab in New York City every day, and every day people prayed. And up here we look for results. Well, for probably for 400 years, the courts of this state have provided results to the litigants, the citizens of the state coming before them. We've had 3 court reforms since 1776 when we became a state. Before that, we had courts of pleas and equity, the King's Courts. From 1776 to 1868, much of what we had inherited from the crown we continued. We did set up 3 Superior Court judges in 1778, divided the state into 3 divisions or districts, and they rotated throughout the counties of that time by horseback and boat. But in 1868, the people of this state passed a constitutional amendment, established a court system that started out with about 12, 15 Superior Court judges, At one point 15, it was dropped in about 1875 to 12 and then pumped back up to 15. But as the years went on, the local courts, which primarily in the early days were justice of the peace courts, commenced to proliferate. And any of you who have ever dealt with the legislature know that local legislators like to get something done for the people back home. And the people back home want their own local court. They don't want to go from Fuquay Varina to Raleigh to court. They don't want to go from Pilot Mountain to Mount Airy to court. And so eventually, by the mid-50s, we had about 256 different courts in this state of limited jurisdiction. We had about 170 to 80 recorders' courts of some type. Some had county jurisdiction, some had city jurisdiction, some had township jurisdiction, some were limited in their jurisdiction to juvenile court, some limited in their jurisdiction to civil court, some covered all of the county, some covered just a town or two. My own Surrey County had 3, Mount Airy, Pilot Mountain, and the rest of the county. Here in Wake County, you had 9. And those of you, few of you, that were practicing law in the early 60s, late 50s. I'm sorry Judge Winburn is not here. He at one time had thought about coming. Judge Winburn was the Raleigh Recorder's Court judge in the 50s and early 60s. But you had, as I told Robert, you had a recorder's court of some type in just about every village in the county. Only Knightdale and Morrisville had no had no recorder's court. Fuquay Varina had theirs, Zebulon had theirs, Apex had theirs, Cary had theirs, Wake Forest, just come down the list. Raleigh had its court, recorder's court, and then there was a Wake County juvenile and domestic relations court. Well, that was replicated all over the state. And all of them had differing fees, differing rules. Many of them were fee supported. The justices of the peace, by which the mid-50s there were 925, were fee supported, which meant if you were charged with a criminal matter and they found you guilty, they got paid. If they found you not guilty, they did not get paid. A lot of convictions in those days. So by 1955, Chief Justice Barnhill and then Governor Luther Hodges decided something had to be done to return some sort of uniformity to the system. Something that would keep people from being ambushed when they went from Raleigh to Fuquay Varina with regard to the local rules, with regard to court fees. And so they asked the state bar, the North Carolina Bar Association, to develop a commission. They did, now known as the Bell Commission, chaired by Spencer Bell, a very prominent attorney at the time from Mecklenburg County, later became a federal judge, Fourth Circuit. But Judge Bell and his commission developed and recommended to the 1959 General Assembly a whole series of reforms, primarily among them the establishment of a district court division of a general court of justice, collapsing all the courts in the state into 3 levels: appellate, superior court, and district court. And the big change was the district court system. Now, it failed in the 1961 General Assembly, came back again in 1963. It passed. Excuse me, I'm sorry. It failed in the 59 General Assembly, passed in the 61 General Assembly. Ruffin Bailey, then a state senator from Wake County, was one of the leading proponents that guided that legislation through. At the time, there was no proposed legislation. At the time it passed in 61, the constitutional amendment. Submitted to the people, they approved it in 1962. Then in 63, what was called the Courts Commission had developed a structure that was approved by the General Assembly. Beginning in 1966, we saw the introduction of the district court system. The people enacting the legislation had the wisdom, rather than making it effective statewide immediately, to phase it in over a 4-year period. And so beginning in 1966, you had the first of what were to become 30 judicial districts that came in with the district court replacing the recorder's courts, the justices of the peace, the mayor's courts, all the 250-some different courts and 995 justices of the peace. The district court had judges, it had magistrates, each with their own jurisdiction. And as it was phased in, 66, 68, 70, the old courts were replaced. A number of the recorder's court judges throughout the state ran for and were elected as district courts, district court judges. Judge Winburn being one, Judge N.F. Ransdale, who was one of the original 5 judges here in Wake County. My father, who was a recorder's court judge in Pilot Mountain, a paid position, paid appointed position, I think $100 a month, something like that. Judge Winburn was the highest paid pre-district court or pre-recorder's court judge in the county. He was paid the magnificent sum of $12,000 a year. Many of the judges in the old Wendell, Fuquay Arena courts were paid $100 a sitting. But since the court was established and the way it came in, there were 6 districts in 1966 with 22 counties. There were 19 districts in 1968 with 61 counties, and then 5 districts, including my home 17th district, 5 districts with 17 counties. Started out with 104 district court judges by the first Monday in December of 1970, when the entire system was phased in. 5 of them here. In 1970, of the 104, 1 female, Judge Elrita Alexander of Guilford County, 4 females, and 1 African American, Judge Alexander from Guilford County, 1 from the Hickory area, 1 from the Mecklenburg area, and later to be Chief Justice Rhoda Billings from Forsyth. As time went on, the courts enjoyed steady growth, both in Wake and here. It's already been noted there were 5 original judges, and that Judge Basin was the chief judge, and that he served the longest here as chief judge. Judge Basin is the longest serving chief district court judge in the history of the state in the first 50 years, with 22 plus years. Now there are 19. All 5 were white male. Now there are 19 district court judges in Wake County, 270 scattered across the state. Of the 19 here, 9 white males, 6 white females, 3 African American males, 1 African American female. When the Recorder's Court went out of existence in Wake County, there were 17 justices of the peace. There are now 26 magistrates. There are about what were called BVO. That's what some of the judges years ago called them, BVO judges. I'm not sure what that meant. But there were 6 to 12 part-time justices of the peace in addition to the 17. And they periodically performed marriage ceremonies and various other functions. I suppose when they, well, no, I'm not going to say that. Well, I was going to say when they might need a little money, but might be some descendant of one of them here, so I better be careful. Now there are 26 magistrates in this county, and there's something over 500 magistrates scattered across the state. So we've had 3 court reforms, 1776, 1868, 1961-62. We got about 40 years to go here before, if history follows the pattern, we will so diffuse the existing court system or become so cumbersome to people that there will be another uprising, if you would, among the public, which is what there was in the 50s because things were so confusing and because the courts were so dependent on fees, and you had you see what happened in Ferguson, Missouri, when the courts were dependent on fees, and the town itself had grown accustomed to, I think, something like 60 to 80% of its budget coming from court fees. And so the people got tired of that in the 40s and 50s. And hopefully, this system does not regress to that. I have some concerns that that's beginning to happen, and that's a topic for another day. Other than to note that when we first started out in 1970, there were 30 judicial districts in this state for all purposes. If you were in the 10th Judicial District, you knew it was for district attorney, district court, superior court. If you were in the 17th District, you knew it was for district attorney, superior court, district court. Now we have, we've got something like 44 prosecutorial districts. We have 44 district court districts, but only 41 for administrative purposes. And we have 44 superior court districts. And so this slow erosion, I'm afraid, is beginning to occur. And there are lots of other examples I could give you, but I'm about to trespass on your time. Some of y'all know my cousin, Bill Freeman, over in Winston-Salem, former district court, superior court judge. We grew up together in Dobson. One day we were headed over to Mount Airy in the pickup truck, and we passed a friend of ours riding a mule. And we pulled over and asked him if he wanted to ride to town. He said he did. We said, "What about the mule?" He said, "Leave him here. He's been to town before." And so we did. And he hopped in the pickup with us, and we headed on over toward Mount Airy on old 601. Going about 45 miles an hour, looked in the rear view mirror, there was a mule right on the back of the tailgate, tongue hanging out. I said, friend, wait, your mule's going to drop dead. He said, don't worry, drive on. We put up to about 55 miles an hour, looked in the rear view mirror, there was a mule, tongue hanging out, ears laid back. I said, your mule's going to drop dead. He says, no, drive on. Finally, at 65 miles an hour, I looked in the rear view mirror, and there was the mule. About that time, we'd hit White Plains, which is where the Siamese twins, original Siamese twins, are buried in White Plains, North Carolina, which is halfway between Dobson and Mount Airy. They had large families. That's, if you want to know how sometime, I'll tell you. But in any event, about the time we hit White Plains and before we got into Mount Airy, we looked and there was the mule still on the tailgate, but now his eyes rolled back in the head, ears laid back, tongue hanging out. I described all these symptoms to my friend. He says, don't worry, drive on. By the way, he said, which side of the mouth is his tongue hanging out? I said, on the left. He said, don't pull the left. He's getting ready to pass. And so what I would say to you is that hopefully the courts of this state will continue to pass and surpass all the others of the United States in their work, and that we will all work together to keep them a uniform, unified court system that people all over this state, whether they go into court in Clay County or Currituck County, they will know that there is a basic level of justice that they can expect to receive. Thank you.
Franklin, I just want to thank you for sharing your time and your words with us today. That was a very insightful talk, and I'm sure you'll have questions on your way out. But thank you very, very much. Another round of applause, please.
I haven't heard anybody say it. Maybe they have. I was a little late getting in. But today is an election. So if you haven't voted, vote. We have a Supreme Court race and a Superior Court race in this county.